Started. There you go. Hey, good afternoon. This is Chip Merlin. I'm here with Larry Bache. So we got a dynamic duo. But today it's not just me. I wanted to specifically have Larry come because he's been battling so many of the roofing claims, and especially the roof issues with respect to matching in Oklahoma and Colorado, Missouri, Kansas, and some, the Midwest, what I call the Midwestern. A lot of the roofing issues and the damage from hailstorm keep popping up over and over. And it's a great debate because it's one that's really, not going to go away anytime soon. I think that insurance company adjusters they tend to have a look at this as almost as if policyholders are going to have some type of windfall in the event the policyholder is paid for more than just the damaged amount of the property. And there to be said, on this particular topic, I refer to these things in the handout. So I know Megan, Megan's over here on the side. I can't see her, but I can see her right now. And so things start popping up. But one of the things I want to make certain everybody's going to get are the handouts, because I promised the handouts that everybody's going to show up. And we have some really great handouts. One's a matching paper that's from a defense firm out of Louisiana, but I found it to be one of the best matching papers that they keep up, and I think everybody would have that. Another's article from Michael Rabin, an article in Adjusters International about pair set match, about the pair and set clause, how that can be used, especially in hotels, and I'll go through that. And there's Jay Feynman had written an article, the great professor from the University of Rutgers, who's also leading the charge with Amy Bach and Holly Soffer on the insurance coverage issues that's really plaguing policyholders. And one of those coverage gaps we'll even talk about today is the insurance companies are trying to write out the coverage that's traditionally been there for people under replacement cost coverages. So I'm Chip Merlin. Most everybody knows who I am. Larry, why don't you tell everybody a little bit about who you are?
Sure. So for those of you that do not know, I'm Larry Bache. I've been working with Chip since I came out of law school. I actually clerked with Chip in law school for about 2 years. Got to fly all over the country and handle bad faith cases, mostly in Texas from Hurricane Ike and different storms, including Sandy after that. Been here for about 10 years. I'm now one of the managing attorneys for the Colorado and Oklahoma office. And I do a lot of work in Florida with Hurricane Irma claims and Hurricane Michael right now. One of the reasons why Chip was nice enough to meet this Tuesday with Chip, I do travel a lot in the Midwest. I do a lot of hail claims and I help a lot with these issues of matching or reasonable uniform appearance. One of the issues that a lot of people struggle with, hear a lot of this from insurance adjusters, is that a policyholder cannot benefit from an insurance claim. And if you hear history, which Chip makes sure we do, we get into that goes back to an actual cash value period. In reality, of course, a policyholder benefits from an insurance claim when they purchase replacement cost coverage. So today's presentation exactly is what Chip said. We're going to go through really what issues are, why the carriers have a hard time dealing with those issues. We're going to get into some examples of why there is coverage. We're going to get into some case law, really explains the reasoning why there's coverage and why there may not be coverage and what is required. And most importantly, who makes the decision. And then we're also talk about some exclusions. Carriers now have evolved and they're including anti-matching provisions or sublimits of liability for specific types of property that in the past, matching or reasonable uniform appearance has cost them a lot of money. Just two common examples that we've seen is with tile flooring as well as siding. Then we're going to have Chip discuss and how the reasonable uniform appearance or matching rules apply. Chip Merlin has handled more FEMA cases than anybody that I know, so I do believe he's the person to answer those questions. And then most importantly, we try to provide resources. Right now, everybody is really trying to get out there and put themselves out there as a marketing mechanism for business during this time. But in reality, what our firm is trying to do is we're trying to take advantage of expanding people's knowledge and basis. And one of the ways you get better is understand what And that's why we're also providing resources. In addition to the resources that Chip identified, if you log in and click on the PowerPoint presentation that we're going to go through together, you will see that there's hot or links to documents that we are going over. And this is very important because whenever we dive into a topic, obviously on a Facebook Live, we can't get into the topic as detailed as we want to. The idea is we want you to take away something from the presentation, some key points and learning, but it's you have an understanding of the why. And so providing you this information, you can take the answers and understand the why. And maybe you'll follow up with some additional questions. You can also ask us questions during this Facebook Live. We'll try to get to those questions today. If you do not reach us today, then obviously we're available. We have more than 60 lawyers that can answer your questions through email, or you can just go to our website. And if you search this thing called our blog, check about how they can go.
Everybody searches our blog. All you do is Merlin blog, and you'll get to it. Actually, now they made a second blog, so you're not going to get there. They got one for the pay up that's sitting back here. This is unbelievable marketing, and thank you for everybody who's bought one of these books. I've gotten a lot of comments back. I was surprised that people actually like reading the book and they didn't fall asleep before they got in, which is amazing to me. But still, at the same point, I like questions. I like when people ask questions. I like a little bit of fun doing it. So please write your comments and your questions. Please go along. I want this to be a learning exercise. You can always try to stump us as we're going through this. I don't mind some shots at that either, because this is how we go ahead and learn as well. But in terms of the government, and I think Larry talked about, historically the policies were written on the actual cash value base. And the truth of the matter is, with the development of the replacement cost policies and the ability, since legislation allowed people to buy replacement cost policies, the entire concept of being better than what you might be before is constant in a lot of these cases. They seem to dovetail, the issues with respect to the person bought a replacement cost policy. He is intended to be in a better position afterwards. The betterment that might be prohibited under an actual cash value analysis that we talked about last week, it is, especially when we start talking about matching. For those of you who are looking at these things, there's commercial policies, you have residential policies, a little bit differently. So some article policies, a lot of these start to go up with respect to jewelry cases, and I'm going to get into that a little bit as well. So where are we on the PowerPoint?
Yeah.
Larry, I'll let you get going on it.
So just make sure I can see the questions here. So as we go forward, I don't know how to pop them up. Okay, so I think I want to. All right, so if you please open the PowerPoint. Some of this is going to be a little bit dense. It's really try to educate on the why, and then obviously we'll have more general concepts as we move through. But anytime you talk about insurance contracts, it's like I'm talking to a jury. I have to show them the actual language of the policy, and so they understand what we're talking about. So the first slide after the bio, you show a picture of what we're kind of an exaggeration of a roofing system that is clearly mismatched, but for a purpose. And it's kind of a joke about what would an insurance company deal with this situation. And the second one, more of a common example, where you have a roof that's got different colors, or you have a discontinued shingle. In Florida right now, in South Florida, we're dealing a lot with discontinued tile, right? If you're doing Hurricane Irma case, you're going to have discontinued tile that's no longer manufactured. And we have to consider what's a reasonable uniform appearance, and the insurance companies have an understanding as to why they owe it. If you're in Panama City Beach, you're going to deal more on the residential side with shingle roofs. And this is a good example of you have in that area where you have mismatched shingles.
And I go to say that there's also a functional aspect that you don't want to go down this rabbit hole, with matching's one particular issue, but whether or not you can functionally replace a tile that's no longer manufactured, so that the old manufacturer's requirements with respect to a repair are going to meet not just the aesthetic looking of it, but also the functional. Will the new tiles being placed down the roof and being flying away and things like that? Many times when you go back through, you find that the tiles simply don't fit right, don't fit the old manufacturer's specifications. They can't be, by law, placed up there. And the insurance companies are trying to do all kinds of things because they don't pay for a full roof. Let's just be honest. They're just trying to find ways on the severity side to reduce what the payments are for some of these old titles. But the first thing you have to look at is not even the matching issue, which, don't get me wrong, a big issue, because especially when we find we've had some, okay, send us what you think the replacement tiles look like, since you think you can match them so much. And it's ridiculous because they don't match in color what they send us. Hey, try again. You get 3 or 4 times in a row just trying to get the match, and it just doesn't work out. So that's, but the first thing to take a look at, especially tiles that Larry was talking about, is the functionality, because we often find the insurance companies just are going down the wrong, they're going down the wrong rabbit hole to begin with on this in Florida. But Larry's absolutely, when you take a look at this first, the roof, it's obviously it doesn't match. It's from an aesthetic standpoint. There's something that I would like, for most people to start using if you're an adjuster out there, and this is the concern of aesthetic performance. And how does the building age over a period of time? And it's something that you'll find, it's a constant architectural building construction reference materials. It's called aesthetic performance. And so that when you're putting, replacing, repairing things, can you actually do it so that the building will perform the same way? And a great example of that is, it looks like it matches today. And I remember this with Dick Tutwiler down. He says, "Chip, let them put the stupid thing up. They want to do a repair that way. Give it a year." And sure enough, in the Florida sunshine, and this is after a loss in Hurricane Andrew, a year later, we walked back and says, what you guys tried to do is like a checkerboard right here. And that's because of the performance, the actual aesthetic performance of the material that was supposed to be the repair material, doesn't age at the same rate with respect to other material that was there beforehand. And so eventually it showed, while it looked like it had a reasonable uniform appearance to begin with, it's over a period of time. How do these things go ahead and age then? And talk about it all you want, but there's some insurance carriers going to go ahead and do we're going to go ahead and right to repair. And in that case, we let them invoke a right to repair to a building just to go ahead and laugh, because then they paid a lot afterwards. And it's crazy what trying to do to save some money by doing repair work. But please be careful about, the functional aspect first comes first, and the concept of the aesthetic performance. You can look it up, and it's something I don't often see, and other adjusters should be raising that question, all along. So, but this is obviously an example where it's not a reasonable uniform appearance. A couple other things in the cases that we try to do on this when it's close, and that is, if it's not reasonable uniform, can somebody see it? And we'll actually literally get an architect to give some opinions on this, but we also get real estate appraisers to come in and say whether or not the repair is done in such a way that it's depreciating the amount of the building afterwards, or the piece of property afterwards, because of the manner of the repair. Obviously not, the policyholder shouldn't be worse off than what they were before. And if the new purchaser of the building would say, it looks like it's been fixed, it doesn't matter, I want you to go ahead and take off some money for that, or go fix it up, one of the two. That's a pretty good tell that it's not a reasonable repair. It's brought back something of like kind and quality. So, using those tests, and so people ask me, how do we get around some of these things? Using getting architects, real estate, getting interior decorators in some instances to make these are great experts to disprove the other side when they start coming up and saying, be here. I don't know if you hear that. It sounds like a whale or something about to die in Tampa, but I hope everybody's not hearing that, but I can hear it right here. But that's the way it is.
All right. So before we get to kind of the burden of proof issues, I know that people are emailing or asking us about, how do we deal with used tiles, boneyards? How do we prove if a tile is discontinued or a material is discontinued, and what the ITEL and different processes that we can follow. But right now, what I want to focus on the next slide is, what is the issue? What requires an insurance carrier to consider matching or reasonable appearance? And so if you go to the next slide, this is standard policy language. This is standard policy language. And it's the all risk language.
I was just making sure you put the part in red like I told you to. So the part in red is what the insurance company is going to come up with on the standard language. They're going to remind you that all we pay for is, quote, direct physical loss, or damage. And what they mean is so that we only pay for those damaged shingles. The undamaged shingles we're not going to pay for. And I'm using this as in a class sense because I was reading, it looked like Bill Wilson was one of the instructors for the Big I on one of their, and this is an insurance agent organization training and things like that. It's fantastic, the Big I, all kinds of great stuff. And some of the instructors were teaching from this part that is the insurance company's intent to only pay for the physical damage and not the consequential damage, that there might not be a matching to the to the shingles that aren't there. And so you have to understand where the insurance company's coming from first, okay? So what they're saying is that you don't have direct physical damage, Chip, to these other shingles. They weren't damaged, just these, and that's where they start on, and I don't know what else to say about it, but that's what the position is when you keep reading it over and over and over. Just read the policy, we don't pay for the undamaged portion of it. As a matter of fact, you're seeing some policies now saying we don't pay for the undamaged portion of the building. Well, that's great. We understand you pay for the physical damage, the unportioned building of a shingle, but you pay for the part of the, quote, not the shingle. What's the shingle? Let's do, Larry?
The roof.
A roof. That's right. A shingle is attached to a roof. The roof is damaged. And when I read through it, and the agents, discussion back and forth, they had one of their subscribers correctly come back and make a note. You aren't looking at this right. It says the shingles are part of the roof. That's the part of the building that's damaged. It's the roof. When people look up, they look up there. They don't look at the shingles. They look at the roof. The roof doesn't match any longer. And you can see it doesn't match. So the first thing is, what are you talking about? You're talking about a shingle, you're talking about the roof. I always say you take a look at the roof. And it could be, I gave you an example. I said, could you imagine if you had a throw rug out there and part of it got, soiled or stained so bad you couldn't fix it? And the insurance company said, well, we're just going to, we're not going to pay for that rug that's damaged. We're just going to pay for the little 3 inches right here damaged. Nobody adjusts a claim like that. The rug, you got to go get a replacement rug because you can't get rid of it. It's still going to look stupid afterwards. I said, why wouldn't it apply then to the carpet? Why wouldn't it apply to a roof? And those are and I think that subscriber who wrote in, and he goes through the rest of the examples. He goes, so you look at the roof, pay for the roof. It's a replacement cost policy, not an actual cash value policy. We're promising the people that we're going to go ahead and fix or replace the roof. And if we wanted to, we have to go fix it back to a reasonable like, kind, and quality. So if it looks like that other example out there that many adjusters might say, that looks, we're not going to pay for everything else around, so we're just going to pay for that. That is not exactly matching. And but you have to understand where the insurance are coming from on this. And that's Chad. Chad is our MVP. And so Chad's waving to you right now. He works in our IT department that they've been working overtime just like everybody have been all over the place. So I hope what you're doing is working good, Chad. Is it?
Trying.
He's trying, okay? Try, winners do. So, are we doing okay?
Yeah,
so they're here.
On in the camera.
Everybody's, you go. But so long as Chad goes, he'll be able to talk to you.
All right.
On this. So that's the policy language. We'll talk about some of the other policy language there.
I'm not finished.
He told me you got to watch out because if you're just going to run over me if we start doing this since we started.
Yes.
That's the problem with me doing with somebody else.
All right. So I want to break this down step by step.
Step by step.
All right. So step is
slow, step by step.
Yes. Everybody knows under the all risk policy that the carrier is going to pay for the direct physical loss of or damage to covered property. So the reason this issue comes about is you have undamaged property. So initially you've got, like for example, I like these tiles. If you have damaged tiles that have been damaged by hail or wind, you have undamaged tiles that are going to be implicated. You obviously have to consider the repairability factor of those tiles. I know Nathan mentioned that when you repair tiles, you actually are damaging the underlayment. But what I'm really focused on is this issue of matching or reasonable uniform appearance. And the reason why they have to consider it is because the industry requires them to. And we're going to get into the Model Practices Act and additional state statutes that provide the requirements that the carriers have to consider. The reason why they have to consider it is because there is undamaged property that is affected as a result of damaged property being paid for. Okay, the best example is a carpet or a tile or a shingle roofing system. There has to be considerations under replacement costs because the language in this provision, if you're still with me on the slide, is direct physical loss. That includes financial loss, market rate loss, and that goes back to what Chip was kind of in looking at the roof as a whole. Not that we're arguing specific shingles versus the roof as a whole, it's that you're looking at the property as a whole. And has the market value of that property been affected? Has it suffered a financial loss or a physical loss?
Well, first, you got to say there's been suffered a physical loss. It's just in the repair that if somebody, after you repair it, it ends up because the repair is not aesthetically pleasing and people can see it, that you then end up a financial loss that should not the policyholder because of the way of an unreasonable fix. Because again, policies don't pay for loss of market value. They don't pay for the market going down. They pay for when physical things happen to a property. Okay. And the coronavirus right now, these insurance companies say that if you happen to get some coronavirus on a piece of property, it's not damaged. Now, are you crazy, man? People are, if I said you got coronavirus, Larry, I got coronavirus on my shoe right here, you'd be running out and stuff like that because you know dangerous property now. It's like it's radiating and stuff like whatever it might be. But so it's the concept first. You have physical damage to something, and to fix it properly, the policyholder has a double whammy. It's aesthetically not pleasing, but I also lost money because nobody's going to pay for it, back that way, or I'm going to have to pay for it myself to do the right fix because it's unreasonable. If a purchaser was to come buy the property, everybody can see that it is not matching. And I think to get to this next, I'm not trying to say, but next one. Otherwise, we're going to go real slow because it's not made with comparable material and quality. That is, it's discernible by others in the future. And I think a lot of very good adjusters spend a lot of time when looking at this. Can we actually replace this with comparable material and quality? And they ask the certain things that you now know that term. It's that aesthetic performance. The quality of the materials are going to perform similar to the other material that's there, so that the matches aren't going to occur in the future either. So
from a practical standpoint, a lot of independent adjusters that don't even get a copy of the insurance policy. So if you can get a copy of the insurance policy as a public adjuster or attorney, then you can obviously show them why there's actual language in most of these policies that show and document why they have to consider these undamaged elements of the property as well as the damaged elements of the property. And specifically, the first area that I showed you is the insuring agreement. It's the all-risk policy language from the prior slide. Next slide is in the loss settlement provision, okay? This is going to be found in your CP policies and your HO policies. These policies, it's going to have language similar to this. They're going to use the words like, kind, and quality, or they're going to say something within this slide which states the cost to replace on the same premises the lost or damaged property with other property of comparable material and quality and used for the same purpose. Okay, this is important. That's why they have to consider the uniform appearance in the policy is to restore the property to pre-loss condition. Okay, and this is the language, of course, which we'll get into, really discuss about what is a comparable material, what is like, kind, and quality. So the next slide, the Model Practices Act. If you click on the little blue link right there, this will actually take you to the entire act. But specifically, I want to direct your attention, if you have that, it's going to be Section 9. Okay, so Section 9 of the Act lays out the standards for prompt, fair, and equitable settlements applicable and extended coverage type policies with replacement cost coverage. This is important because these are the standards that were set out by the National
Association of Insurance Commissioners, who's promulgated these acts going back since, I believe, the 1940s.
And are they public adjusters? Are they insurance policyholder contractors? Are they plaintiff lawyers? What is the NAIC?
It's all the insurance commissioners that get together and they make model acts with respect to all kinds of various things. Model acts for the licensing of public adjusters. As a matter of fact, just recently was promulgated by the National Association of Insurance Commissioners, but they come up with the model acts with respect to unfair claim practice they apply to especially property damage claims. And this particular one, so it's not something anybody's made up. This is the NAIC, and this is something that the insurance companies know that are out there. And if you go through the training as an adjuster, the adjuster is going to actually go through and read what the Model Unfair Claim Practice Acts are. So they're familiar with them because so many states have adopted them, as we're about to show you.
Right. So I think what's important is I argue with this with defense lawyers all the time, and it drives me crazy. It's not a novel concept that's me trying to recover money I'm not owed for my client or a public adjuster trying to inflate a claim. I've seen drastic measures in Colorado where they're actually proactively suing policyholders over issues for fraud. They're alleged fraud over a reasonable uniform appearance.
Who would do that?
Well, Wheeler Trigg out in Colorado and Denver has just filed a lawsuit against our client.
They're good attorneys, though, so you got to give the devil their due.
But they're alleging because we have damaged wood windows and aluminum windows, and the public adjuster there trying to figure out the right way to handle a reasonable uniform appearance, and included a conservative method of by unit instead of by building or by the entire association, and they were hit with a fraud claim. So they actually filed a lawsuit against our client. So we'll deal with that.
You know, as you go through, Larry just mentioned, when you do represent condominiums, apartment complexes, if you're in an HOA, some of these planned unit, planned areas and stuff like that, they have all these regulations that are in there about maintaining a uniform appearance, within whether the condo or the buildings and things like that. So when you're doing residential or commercial residential, make certain that you get the bylaws for the HOA. Many times, if there's going to be repairs and stuff like that, they have to actually go through and get approved by an architectural committee and things like that. If you live in the historic district, any type of repairs and things like that have got to go get approved. There's actually special policies that cover, for buildings that are historical areas, because the like kind of quality, they don't even let go back to brand new. You've got to use the old stuff back there because they're trying to maintain the quality of the way some certain aesthetic, that the community in that neighborhood has decided to use, and so it can increase the amount of the construction costs significantly. But you need to be looking for those, and a lot of people, for some reason, mistake and don't do it. But you'll find it, as a matter of fact, here. I'm just looking at, we're on Harbor Island, we're in Tampa, Florida right now, and they made the apartment complexes next door and the hotel that's on this side repaint their building after they painted them to was not previously approved in the plan unit, bylaws, agreements and stuff like that all of us have to conform to. So, these are important extra documents to look at when all of a sudden the insurance companies start coming through about, we can use something else. It doesn't have to exactly be that way. No, we can't, because we've got this document over here that says something, and the adjuster should be looking at that.
So let's take a moment and let's read about what the National Association of Insurance Commissioners tell the insurance industry to consider. Okay, and this is section, it's in paragraph B. It says, when a loss requires replacement of items and the items do not match in quality, color, or size, the insurer shall, it's not may, it's not consider, it's shall replace all items in the area so as to conform to a reasonably uniform appearance. This applies to interior and exterior losses. The insured shall not bear any cost over the applicable deductibles, if any. Now, this is important. This is the insurance industry telling the insurance how to handle these type of claims, number one. Number two, it doesn't limit it to interior claims or exterior claims. It's both. All right, so if we go to the next slide. There's a reason these laws or these rules are out there. If you are a longtime insurance adjuster, which we work with a lot of public adjusters that used to be insurance adjusters before they became public.
We work with a lot of insurance adjusters. You have to on the opposite side, especially the older ones know some of the stuff more than the younger ones for some reason, but we got to coach up those younger ones all the time.
So if you have someone that has a professional designation like a CPCU or an AIC, these are in their texts. Like when you take AIS coursework, Markham's textbooks will explain why this is important about fully indemnifying your insured. You really didn't see problems until profit became a focus, because obviously it can increase the value of a claim. But before that, there's a reason why these model acts exist. There's a purpose behind it, and that purpose was derived from how were trained for many years. And that leads me to my next slide, because when I first started in this business, this was the rule. This was the rule that every single adjuster would testify in a deposition apply, and that was called the line of rule. So the question becomes, okay, we have to provide a reasonable uniform appearance. The question is, how do we determine what a reasonable uniform appearance is? And based on the textbooks and based on the training, I was taught it was the line of sight rule. Now, the state statute that I'm providing, that's on the PowerPoint, is from Iowa. So Iowa has actually codified this long-standing adjustment practice or rule of the line of sight. And it mirrors the model act that we just read on the video here. That it includes the line of sight rule. It says a loss requires replacement of items, and the replaced items do not match quality, color, or size. The insurer shall replace as much of the item as is necessary to result in a reasonably uniform within the same line of sight. Okay, same line of sight. Most common example is sighting. You got a hailstorm that comes in, Chip. It hits the north side, it hits the east side. It doesn't hit the west or the south side. Vinyl siding is no longer manufactured. You pull an item board as a public adjuster or policyholder, it comes back, it mirrors the language. They do no longer manufacture that vinyl siding. The question becomes, what is the policyholder?
So it's amazing how I think the insurance companies, when they talk about life, they must be using the evil eye. So if this area got damaged and that area got damaged, look, they stand right here and they say, well, okay, that one, both damaged, I guess they'll go ahead and just pay for that. They forget to walk over on this, where this one doesn't, and here, the line of sight too. So that means you got to walk around and make sure all the lines of sight. You got broad eye, like that monkey I showed last week over there, not like this type of line of sight that I think is out there. Now, I don't think most adjusters are quite that bad, but I've even on the line of sight stuff, it's amazing how their line of sight gets awfully narrow, almost like horses down in a race where they have blinders on them, they can't see more than what's right in front of them.
Yeah, the new argument that I'm hearing is with the line of sight, battle that from an adjuster standpoint, is if you can't see on the ground. And my response to the insurance carriers are, okay, so you can't see my tile roof from the ground, I have to do repairs. But when I still suffer physical loss, because when I go sell my property, they're going to do an inspection report. And there's going to be a market value loss. I've suffered a loss, a financial hardship as a result of this claim. So they try to evolve the line of sight rule, because at the end of the day, when you apply that rule, you're going to have to replace whatever that material. If it's vinyl siding, it's going to be all four elevations. If it's a tile roofing and the hips and ridges and all that, it's all got to be replaced.
Yeah, for some reason, like Larry, he's not too good at seeing this. And I was talking to him about, I said, I bet you don't quite line up in those cabinets on the house you're building right there. I bet you probably don't think twice about it. But I bet right now your wife is thinking, and she probably says something like, I thought you were insuring, Larry.
Right.
You know, you sue everybody. I can't go ahead and threaten this contractor to make my cabinets right now. And what do you tell her, Larry?
Yeah.
Not such a good attorney when it comes to that, or
no, you got.
Yes, honey, right?
Yes, ma'am.
Yes, ma'am. You go. Now that's sometimes that's the measure. I mean, it's what we the guys might say, but I guarantee you, there's a lot of people out there that get awfully upset, and they just don't go away when things don't match. And I think rightly so. It's and you find this on the interior of homes too, and so you have an interior decorator makes things go from one room to another, and her line of sight, you go up right here, it's supposed to match. I made it so it was going to match that way, and I think when you have that type of evidence, it helps on the strength of your argument. And then so we use again a lot of interior designers and decorators that can explain the aesthetics and how it won't pass when somebody comes to buy it later on and somebody financially has devastating. So just because of the line of sight, don't use the blinders the insurance companies have on it, but really think through the way the building is supposed to go. Now there's another law out there, so we go from Iowa to Nebraska.
So we go from Iowa to Nebraska. I am seeing the comments that some of you are having a hard time with the video. We will obviously repost the video with the YouTube link. This is finished, and hopefully that addresses those points. But yeah, so the next slide. So if you go to the slide, you'll see the blue link, and the blue link you to the entire Nebraska Administrative Code. And this is specifically from the Nebraska Department of Insurance. So here's another jurisdiction, another state that has adopted its own version of the Model Claims Practices Act that we discussed. And it mirrors exactly what the Model Claims Act provided. And this is in section 10.01B. It says when a loss requires replacement of items and the replacement items do not reasonably match in quality, color, or size, the insurer shall replace items in the area so as to conform to a reasonable uniform appearance. This applies to both interior and exterior losses. So Nebraska's adopted the Model Claims Act. I did a lot of litigation in Nebraska over the last years, and we took a lot of depositions of the different adjusters from American Family, Farm Bureau, State Farm, Allstate, pretty much all of them. And I would ask them, I'd show them the statute, and I would show them photographs of the damage. And we represented with a contractor that was helping us that did the work on some of the properties. And we asked them for the repairs. So we had the contractor go and do the repairs based on the carrier's recommendation. And we would take photographs before and after. And I would sit in a deposition and I would ask them what their definition of a reasonable uniform appearance is. And they told me under oath is if you can tell that a repair was completed, it would not meet the standard. So then I would take the photographs from these claims, these hail claims, where the repairs were completed. I'd give them a marker, I'd give them the photograph, and I'd ask them to identify where the repairs were made. And Chip, wouldn't you know, every single time, they would circle where the repairs were made, and I would ask the next question, does this meet your standards? No. Okay? Literally, those claims, that's why we resolved over 500 hail claims.
I wish
Right.
they must have some dumb adjusters up there, because all of a sudden the ones I would take, I go, I can't figure out the repair was made. It looks all pretty good. There's some old adjusters I know on this Facebook right in here laughing, going, yeah, Chip, you try to get us on that too.
Right.
So they must be smarter in some parts of the country than others. So I don't know how that could go, but we better keep moving along because we're 38 minutes into this, Larry.
We got a lot of people watching.
See, Larry likes to go over. I like to move things along.
All right, so next slide. I'm almost finished, and then it's all yours, as quick as you want. So the next slide is the Florida statute, because a lot of people are doing hurricane claims in Florida, and there's big miscommunication on this statute that I want to go with today. To start, the statute that is the Florida statute is found at 6269744, but you don't need to worry about that because you can click a little blue link and it'll take you right to the statute. And section 2 reads, well, first it says, unless otherwise provided by the policy, when a homeowner's insurance policy provides for the adjustment and settlement of first-party losses based on their replacement costs, the following requirements apply. So this statute does apply to residential claims only, or homeowners' policies, and it says, when a loss requires replacement of items and the replaced items do not match in quality, color, or size, the insurer shall make reasonable repairs or replacement of items in adjoining areas. In determining the extent of the repairs or replacement of items in adjoining areas, the insurer may consider the cost of repairing or replacing the undamaged portions of the property to achieve the uniformity. So this is a statute that is very important for Floridians and their policyholders. What's important about this statute that I want to address is I hear a lot of defense lawyers, a lot of insurance adjusters, and yes, even public adjusters, that because of the statute only applying on residential claims, they believe there's a requirement to provide a reasonable uniform for commercial claims. That's not true. This statute does not rewrite the insurance company claims guidelines. This statute does not specifically address at all that there's no requirement to comply with the replacement cost provisions of the policies. So when you have a policy that provides replacement cost coverage, that's going to trigger the reasonable uniform appearance evaluation and then trigger the line of sight rule or any other rule that's applicable that you can discuss with the carrier. All right, so next slide. We have matching issues and new endorsements. So what do carriers do to react? They now apply exclusions or limitations in the policy. I'm going to go through these quickly.
So I'll say this. any agent that goes and sells a commercial policy to people or to even policyholders that have got this, you might as well call your practice carrier up front, because you're really doing your client a disservice. And these are really bad apps that probably are against the Fannie Mae and Freddie Mac regulations with to building mortgages that are out there, because they definitely don't allow for replacement and putting back the collateral back the way they used to be, so they're not losing market value, which is what the mortgagees are concerned about. But they're also just horrible policies when people ever have damage. So actually, I say that I love agents. You guys keep selling that insurance and stuff, but if you're going to sell this stuff to policyholders, you're selling a bunch of junk, and you know it. And you ought to put warnings everywhere which way you can about junk that's being sold when it's in these anti-matching language provisions in insurance policies.
Right, and the carrier that does this almost uniformly now is American Family. And so, and here's the disingenuous part of it. They call it their Dutch premium policy, Chip.
Yeah, and you know what? American Family, Bill Wilson actually had one of their press releases about the real bad 1998 storms in Minnesota. And they were like this apology letter to everybody, because they were being forced as a result of a court decision to go back and readjust all these hail damage claims, because they weren't the undamaged parts. So to get around that, they then turn around and sell these junk policies to their policyholders, but they warning. We're not going to pay you if you have damage in a match. And people go, what do you mean? And then give some examples and advertise that, rather than the advertisements they got about being. I can hear the executives if they hear this afterwards, but yeah, American Family out there is just leading the band. Don't buy an American Family policy. It's got this anti-matching, stuff on here. It's really the warning to everybody. And for those agents, you got to tell the people stop writing it, because we can't sell as junk insurance.
Right, and I think what's important too is, because we're dealing with these endorsements, is with American Family, it's not actually an endorsement, it's actually in the body of the policy. And then with the replacement cost coverage as an endorsement,
under the deluxe policy,
deluxe premium policy, it's ridiculous, okay? But we argue that it doesn't apply, because the additional premium that was charged for the replacement cost coverage adds and changes the policy. Enough, we've never gotten to a decision before a judge, right? Because the issue is, it's not to the policy or an mandatory endorsement, it's actually, but then they take the additional money for the replacement cost. But I got to say about that. So this is a good example of what you have to look out for. Chip's favorite quote is, read the flipping policy, right? So make sure you read the policy, understand if there's an anti-matching endorsement or exclusion. We provided a second example on the slide. This just gives you the examples of what they're trying to identify and exclude. One more, this one specifically for vinyl aluminum siding. This would be an exclusion. The next slide is kind of an interesting position that I've seen carriers take with their policies. Liberty specifically, they will not include anti-matching exclusion, but they'll include a supplement for a specific material. So in the Midwest, the big siding. When you get to South Florida, you'll see tiles, right? Chip tile, drop tile. Citizens even has in their standard policy a $10,000 sublimit of liability. The reason why this is important is that as a public adjuster or consumer advocate representing a policyholder, make sure you go over the policy limitations with your client in the very beginning, so that you can avoid, you want to go with the expectations up front, so they know that you know what you're talking about, and their disappointment's going to be with their coverage, not with you. All right, so that's a good example. I'm going to keep it moving. All right, get a little bit into some really exciting case law and turn it over to Chip. I'm only going to talk 2 cases. They're 2 very important cases. I would have spent a lot more time on them if I could, but I'll get yelled at by Chip, so I'll just be quick. The first case I want to talk about is Hamlet versus Hamlet Condominium Association versus American Family. And this case really indoctrinates about how these issues work out through the litigation system. So after this webinar, please click on the blue link, download this case and the next case. And if you read these cases, you will have a very good understanding of what we're talking about and how it actually plays out. Because by the time I'm finished with these 2 cases, you're going to see how it actually gets resolved. And it's important for you guys to understand. So this case is Hamlet. The order is attached. This was a case where you had an ethos issue. You had 20.
I bet the judge's name wasn't Shakespeare, though, huh?
No, judge's name is not Shakespeare. All right, so if you go through the case, you'll see how it talks about some common known insurance law. It talks about the policy provisions that we went over today. But the summary of this case is you had EFIS that was damaged, and you had a certain couple of elevations that were damaged. But on the corners of EFIS and your cap, it's hard to tie in. No matter how many times you skid coat it, you're always going to be able to see that a repair was made. Okay?
Always.
Well, that's what this panel decided. So the issue came, what is a reasonable uniform appearance? And the claim went to appraisal. And Chris Wilson actually was the appraiser on this one in Colorado. And his argument was you have to replace the EFIS because you can't make a repair that would provide a reasonable uniform appearance. But in essence, it's not repairable. American Family took two different positions. One position was, yes, you can. And the second position was, if you cannot, it doesn't matter because our policy does not provide coverage. Because we only owe for what's directly damaged. We don't provide any consideration for reasonable uniform appearance, which we know is wrong, okay? So they went to the appraisal panel. The umpire hired a third-party consultant, engineer / architect expert, who evaluated whether or not you could do a repair. And the court evaluated his testimony and his opinion, his report. His report said, I have a lot of experience making these repairs, and you cannot do these repairs where you're not going to be able to identify the skid coating that's done to make these repairs. And it's my recommendation for the replacement. So I don't want to get in the arguments about the case law as far as the policy goes. Yes, American Family, in conclusion, does have to consider replacement cost policies and matching and reasonable uniform appearance under that policy. So the question became, what's a reasonable uniform appearance? And both parties moved for summary judgment, wanting to win their position. American Family said, no, you don't have to do it. Here's our expert that says it. And the policyholder said, no, you do have to do it. Well, the court made it really simple. They said the claim went to appraisal, and that's the trier of fact. And if the appraisal panel determined what would be required for a reasonable uniform appearance, place all of the EFIS, then who are we as the court to say that's not correct? The court gave deference to a trier of fact, okay, and gave deference to the panel that made the decision that you have to place it. What does that mean? Because it's a double-edged sword. If the panel would have decided that you could have done the repairs, right, then the court would have given the same deference to that situation as to what constitutes a reasonable uniform appearance. As a trial lawyer, how does that work for our deference? Well, it means in Colorado and these other jurisdictions, we're not going to win on summary judgment as to what's required for a reasonable uniform appearance. It's going to be a jury. It's like Chip alluded to, my wife and I might have a different definition of reasonable than you and your wife might have, you and your friends. So a jury, from one jury to another jury, might conclude, yeah, you have to replace all the EFIS. And another jury might conclude, no, the repair is fine. It makes sense. So at the end of the day, it's a question of fact, okay? So how do you want to handle that? Provide a reasonable position and support. Talk to your policyholder. Ask them what they actually expect. I don't ever want to be in a situation, I know you don't want to be in a situation where I've got a public insurance adjuster asking for all of the buildings, and my board or my client, the policyholders, say, no, we're fine with the repair. If we can resolve this and gets done, it's fine. So make sure you know what your client wants. Make sure it's reasonable, because sometimes they may be asking for something that's not reasonable, and you have to explain to them why it's not. But the point is, generally speaking, how you define reasonable uniform appearance is not going to be a yes or no. And I know as nerds, I always get the questions from public pitchers, contractors, and my clients, what's the answer? And they always hate the lawyer answer, which is, it depends. Okay? And these are typical.
But you're the one giving the it depends answer right here. So just remember it came out of his mouth. And there's a quick explanation of a case.
All right, so I'll move on to the next. I'll be even quicker. If you read Cedar Bluff, is Tim Johnson and Jaden Smith's case out of Minnesota. Great policyholder attorneys over there. They did a really good job on this case. Same issue, but this time they were dealing with vinyl siding. It won't surprise you. American Family was the insurance company on this one.
Why is it always American Family?
I don't know. It's auto owners and American Family in all the case law recently. So
if you avoid litigation, don't buy an auto owner's policy and don't buy American Family.
All right. So the purpose of the case, same exact logic, same reasoning. Appraisal panel made the decision. This is precedent that the Colorado court relied upon and give deference to the trier of fact, whether it's an appraisal panel or jury. Importantly, that means there's not fraud. Okay? If it's a question of fact and you disagree on somebody's reasonable uniform appearance, if you have aluminum windows in the entire complex and you expect them all to stay aluminum, that may be reasonable. Or if you have to do paint that has to match all of the buildings, that may be reasonable depending on the facts. Maybe it's reasonable to only paint one of the buildings. But the point is, it's a disputed question. It's not an issue for fraud. It's not an issue that should be addressed that way. It has to be addressed by a jury. All right.
Well, I'm going to go quick. So first of all, if you go, and this is in the, Megan says it's, I know it's in the document, some of the information, great papers, one of their updated papers that has to do across the nation with respect to the issue of matching. Jade Feynman has one as well that we've got in there. The FCNS, the bulletins, we've got discussions. As a matter of fact, there's a real good one that is August the 27th, 2015. That I was reading earlier today when I was getting ready for this, talking about damage to siding. And maybe, Megan, I can send that to you afterwards and send it and just put this up for everybody. Maybe I'll write a blog about it because I thought it was a good discussion about damage to siding up in the Rhode Island law. If you don't subscribe to the FCS, we do. I think you get a lot of good discussion in there, and the FCNS has a lot about that too. This organization is getting much better, ERMI, and we subscribe to it. I think some of the discussion there, it's not to say that the FCNS isn't as good, but some instructors there aren't there anymore, and some of the new people just don't have as much experience going back at the FCNS. That's my opinion. Don't get me wrong, I still subscribe to it and everything else they got, but ERMI is really coming out with some great articles and materials discussing some of these issues. You've got to watch out on these new policies. So, read the whole policy and what I'm talking about on this, because policy language is changing and you can't accept anything from what, because they're trying to get out of insuring these for some reason or another. And sincerely, I know there's a lot of good hardworking people at insurance companies. There must be some reason why this out of coverage. I always get to you trying to market better and trying to make your profits by not disclosing everything. But if there's a whole nother reason why you're writing these in there and why other companies aren't, why you're not advertising that our policies everything cover, let me know. So we into these limited, like Larry was talking, limited matching coverage that I'm going to talk about with respect to Citizens, I guess, and some other companies, because we'll go to them. And now you want me to talk about national flood insurance. Now, there's a lot of people that have done more flood insurance policies than what I have, but I've done a bunch. One of the great things on this, are we still moving ahead on this?
Yeah, so let me just bring everybody up to speed. So we are now going to move into part of the PowerPoint. So on national flood claims, probably the best thing, if it's not damaged, if it is not damaged, okay, they aren't going to replace it because it doesn't match. And they have regulations about that as it comes out. Now, don't get me wrong, I talked to Russ Tinsley, and I guess Russ is still working in the national flood. I don't know if he's left. He seems he's worked there. He worked at Bankers Insurance Company doing flood stuff back in the 90s, and then he started working for FEMA after the flood insurance program. So I've always had a question with Russ. I would just give him a phone call. And we had discussions about this, and just because it's not matching, if you have to destroy the undamaged property to fix the flood damaged property, that gets paid for. And Russ pointed me to the right part, and he's even got in his regulations. I try to say this to people all the time. Instead of talking about that slide, they end up talking about the non-matching slide. Right. And so it's very, very important that you switch the two, because many times, especially when you get the capture, you can't pull something out without doing damage to the undamaged portion. And when that happens, you're supposed to be replacing that as well. So if I could, when you go back and you get these materials printed off, if you look at the Model Practices Act and the statutes, you'll notice that the sections I've directed your attention to for the Model Act, it's section number 9, and I directed your attention to section A2 that talks about matching or reasonable uniform appearance. The section right above that talks exactly what you're talking about, consequential loss. And the language I believe you're referring to is when a loss requires repair or replacement of a part, any consequential physical damage incurred in making such repair or replacement, not otherwise excluded, shall be included in the loss.
And that was part of the discussion in the FCNS bulletin I was talking about too. So you wouldn't even have to get to the whole issue of matching. It has to be taken off the undamaged portion just as part of the construction of it. You take care of that first. Okay? It's if you say you can do the repair and you can do it in such a way that it's going to be next to items that are not undamaged. Do they actually? Is it a mismatch afterwards?
Like if you've got siding that's tied into a roofing system, right? It's terrible. I mean, I get it. It's a bad problem to have, but you got to replace the roof to tie it in. You got to remove the siding. And now what if that siding is no longer manufactured? You damage the siding when you're pulling back the siding. It becomes a problem.
Now, I know everybody's not an adjuster worker for Justice International, but they do have a great newsletter that comes out, and they had an article on pair, set, and match that I wanted to talk about, because most of the time when we start going down these policies, somebody starts saying, well, what's the whole, when you read the policy in its entirety, Wilson talks about, read the policy in its entirety. What does it do? And you get to these, topics about, we're going to pay for, the damage or the value of the pairs and the sets and stuff like that. So that, and this is especially important to, I know we pulled this out. This is a hotel room. I actually asked Megan, this is a Carlton hotel room. Now, the Ritz-Carlton flag, because, the franchisee-franchisor, relationship, and if you go to anybody, we're representing the Chevrolet dealership up in Marianna, Florida, and even they have ways that their showroom is supposed to look. The way, because it's a brand that they want to start the training. So anytime there's all kinds of franchisees and franchisors, but most of the time they have the aesthetics of the brand that are important. My sailboat with stuff like that. We even have from North Sales that's, with us, their color blue has to be in a certain type of blue. It's got exactly that way. They send us that, something for those companies and in the way that they actually perform and how they generate revenue with respect to matching. And so, for heaven's sakes, if you ever get anybody in this franchisor, so this is all hotels, but almost anybody that's the P-Dops, all these various businesses that are out there, it's important that you consider the building as well as materials and the equipment with respect to what they're required to do under their quote flag or their brand. And you need to get those documents, and you need to think about whether or not I should be making a claim, because the rooms don't match anymore. They keep what's called furniture. They get enough of these replacements and stuff, and in the event they do have some damage to them, that the rooms can keep that uniform appearance, but sometimes the damage is so bad that's gone. And those types of claims are quite often. It's a great article that Michael Raven wrote in there, and that's going to be included in the handout for everybody to read afterward in some of the cases, but it often gets misplaced. If you have I guess we got to the first one with I had the jewelry on. You have to be careful on jewelry policies out there. It's real. You have to read the jewelry policy, because they have something that's called the standard form of that is where they don't have the option to do the where they the option to do the replacement, versus the broad form where the policyholder is much more in charge with respect to that. And especially in jewelry, you can imagine what would happen. Whoops, I lost this earring over here, like Larry and his earrings and stuff. So Larry lost one of his earrings over here, like for gas pirate earrings, okay?
Pearls.
And he's all upset because now he doesn't have a matching one. Some people might say he would look better if he just wore one and stuff like that and just, gave it up. But anyway, if he wanted them to both match, there's this moral risk that somebody just lost it, and they're always worried about that. But you got to read the policy on every single one to figure this out. Most of it works is the insurance company has a right to go ahead and pay for the value of the set and give up as salvage whatever it is in the parent set. And that's very common with commercial policies. And sometimes you can go back and buy the salvage from that. So, because the insurance companies want to get rid of it, they got to sell it to somebody afterwards, and sometimes sell it back to them. But, if you think about it, and we talk about direct damage, I always get to my shoes. So I got, just like last week, I got the shoes back in it. Megan's laughing. You know, so what happens if this shoe got damaged, but the other one on my foot, it didn't get damaged? You know, now if I had one leg, maybe it wouldn't matter. I only needed one shoe, but I got 2 feet. So you got to wear them both. It doesn't do you much good to have one destroyed shoe, does it? So it makes a lot of sense why we have these policies, because I swear to God, some insurance out there, if we didn't have the pair and set clause in the chip, we're just going to pay for one of the shoes. We're not going to pay for both shoes as if I only got one leg. It's not fair, is it? So thank God we got that in policies. And when you read that, and you start arguing about replacement costs and pair and set on the people's expectations of what coverage ought to be, unless the insurance company really makes it clear, you know, in their policies, they're not going to be paying for any matching whatsoever, but limitations, and they really make it clear. The agent is making it really clear, because nobody would expect just to walk away with one shoe after this, or have the way that shingles look on their place, or have the devalued home or building, or have to come out of pocket to make it look the way it is because the condominium association requires it, or the plan unit development requires it.